We have just under an hour, so I am going to dispense with long introductions. This panel really doesn't require them. I don't know if our mics were on earlier, but you missed an extraordinary exchange between Ted Olson and Justice Breyer on the meaning of the Equal Protection Clause, because Ted noticed that all of you in the audience had access to drinks from the bar, so he insisted that the clause apply here as well.
Only right.
And we do have to end at 9 o'clock unless, Justice Breyer, you're going to take to the drums and we'll pretend we're the Supremes. But there actually is going to be someone coming in and playing after this.
And we know their songs.
Yeah, we actually have it right here. But it's respect.
I am, I said, it
right,
says.
Right. One person does need an introduction, or a brief one. Stephen Carter could not be with us, and he regrets that. So we asked Michael Sandel, very distinguished political philosopher from Harvard, to join our panel. Ted Olson was one of the most respected Supreme Court advocates in the country, and I would argue in actually American history, with a singular record of success representing the United States in the Supreme Court, and of course the lawyer who argued the cases in the Bush against Gore cases that determined the outcome of the 2000 election, and of course the incomparable Justice Stephen Breyer.
Thanks a lot, Elliot.
Anytime, Ted. And of course the incomparable Stephen Breyer, who writes dissenting opinions for the Supreme Court of the United States.
I think this is your crowd.
I'll get the conversation going, which doesn't look like it'll be very difficult, but I do want to give ample time for questions, so do be thinking about them. Justice Breyer, this was, I think, your 13th year on the court. Perhaps not the most fortunate number, nor the most fortunate in your ability to forge majorities. And I'm wondering if you would tell us how this term may have been different. Historians are already saying that this may have, in fact, been a key transitional year or a special milestone in the court's history. But how does it compare your experience this year with your previous 12 years on the court?
I don't know if this has anything to do with it, but I remember reading in my history book, there was a man called Damien who tried to assassinate Louis XV. Now, he was caught, and they sentenced him to being hanged, and then he was going to be drawn and quartered, and 4 horses were tearing him apart. And the morning of his execution, they came in and said, "How are you this morning?" He said, "It's going to be a rough day." I'd say if you go back in a more serious, I've been there 13 years, that's true. And I think over time, anyone who's appointed to the job has begun to see the Constitution as a whole. That is, the difference between the job on the Supreme Court and in a court of appeals is really courts of appeals deal with the Constitution in bits and pieces occasionally. But for us, it's a steady diet. And therefore, you begin to understand the document as a whole. And it takes time. There's no doubt that it takes time. But I'd say my own view of it, which is I probably shared across the board in general terms, is this is a document that, first and foremost, creates a democratic political process. I mean, people don't understand that. The first 7 articles are trying to create a democratic process. Now, it's a special kind of democracy. It's a democracy that protects human rights. It assures a certain degree of equality. It divides power horizontally, 3 branches of government, vertically, states, federal government, and it insists upon a rule of law. All right, having said that, which takes about 40 seconds, most people will agree. Well, then what is the job? I say I'm there to interpret the Constitution. I'm doing my best to interpret it. I don't believe I make it up. I do believe I'm trying to get the heart of the document. And what I see our job as, to use a metaphor, is the document gives the public the power to decide things, but there are boundaries. There's a frontier. And didn't I say it's a special kind of democracy? Basic human rights, equality, etc. And our job on the court is, I'd say, we're there at the frontier. We're trying to say, does this law or this action or that action go outside the frontier? People sometimes think what we're doing is we're saying what's good for everybody. I never think that. I mean, nobody really thinks that on the court. We think what we're trying to do is to decide whether what other people have done, usually the legislature, has gone beyond those boundaries. They're the ones, and the people to whom they're responsible, who decide what's good for the country, what's good for the city, what's good for the town, what's good for the state, what's good for the nation. We're the frontier. Now, I use that metaphor because it immediately will call to mind the fact that life is sometimes very rough on the frontier. And indeed, the cases that we have are arguable outside, arguable inside. That's what we're trying to figure out. Right. Now, you see the nature of the job. So with that as a background, we have about 80 cases in the year, probably close to half are statutory cases, maybe close to half constitutional. What was different about this year? Well, there we are. I mean, if I look at the numbers, if you're interested in numbers, I would say I look back to the year 2004, which was Sandra O'Connor's last year. Sandra and I got on very well. I mean, I liked Sandra very much as a person. I liked my colleagues as people. But we had very much a certain cast of mind as to how we looked at things. We agreed quite a lot, not always. All right, so I take that year 2004, 2005 and compare it with 2006, 2007. First, usually about 30 to 35% of our cases are unanimous. This last year it was 22%. In 2004, or usually, I usually say 20 to 25% 5-4. I usually say that. In 2004, it was 22%. This year, that number of 5-4s went to 33%. Then I usually say, and it's not always the same 5 and same 4. We're sort of split around. I mean, and I compared that. I looked at those 5-4 cases, and the 5-4 cases in 2004, let's see, 5-4 cases, it was around, I think, 55% of the time that it was the same 5 or 4. Do you see what I mean by that? I'm taking me, say...
You were usually the 4.
Well, we weren't actually, interestingly enough. Yeah, I'm going to go look this up because I don't want to be... Here we go. Oh, well, where are we here? Yeah. No, I'm sorry. Go back to 2005. I was in the majority. Well, forget that. The point is, the 4 of us voted together about 55% of the time in 5-4 cases 2 years ago. This last year, we voted together 80% of the time. So, as far as me personally, you mean you think I ever am interested in myself personally? I'm different from all other human beings in that respect. No, if I go back personally, I wrote that number down too.
I'm surprised you have to consult notes to figure out.
Yeah, I do. Here we go. I was in the non-unanimous cases. Non-unanimous, so we get rid of the unanimous ones. In 2004, I was in the majority 82% of the time. This last year, 55%. So there's a big drop, big increases in what I'd call the 4, 5, and a drop in unanimity, and a big rise in 5-4s.
Yeah. You've gotten the cases wrong more recently than you did 2 years ago.
Well, just to continue with that, Ted.
Right.
Ted, my guess is that your reaction to the differences this year compared to last year, not necessarily as an advocate, but rather as a very distinguished conservative constitutional scholar who has had a lot to do with the development of organizations like the Federalist Society, and who has strong opinions about the kind of judges who should be interpreting the Constitution, original intent, and the like. I would assume, from your perspective, that the changes that made it not exactly a drawing and quartering year, but a challenging year for the justice, were welcome ones from your perspective. But I have a question about it from your conservative jurisprudence. One of the statistics that one could look at this year is the number of cases that were explicitly overruled. There were at least 3 cases overruling precedent. And there were at least another 7 or more where either the dissenters or the concurring opinions in the majority said the majority, the plurality opinion may say that it's not overruling a case, but obviously it's overruling a case. I would have thought that one of the central tenets of conservative jurisprudence is respect for precedent and tradition and what lawyers call stare decisis. How...
Whose side is this audience? Where did you get these people?
How?
You all...
But I assume you, though, have an answer to that, and in fact, that you're not troubled by those cases that are overruled and what that means about the role of Supreme Court.
Well, in the first place, I think, let me say a couple words about the court first, if I can.
Please.
I can do that. The court is a remarkable institution in American government. These 9 justices serve generally for 20 to 30 years, which is 4 to 5 to 6 to 7 presidential terms. They are a remarkable group of people. I've practiced law before the Supreme Court for a long time, and I have never failed, and I lose cases. One of them, which we were talking about back there in the so-called green room, I lost 9-0. And I don't think that, so as John Roberts once said, when someone asked him why he lost a case 9-0, he said, because there was only 9 justices. So I'm not talking about whether I won a case or lost a case or agree with it. The justices on this court are a very collegial group. They work well with one another. They are invariably extraordinarily well prepared, and they ask very difficult, penetrating questions, and they do their work in public in the sense they go back and render their decisions, but where in the world do you have an institution of 1/3 of your government where they listen and look at the citizens, they hear the arguments, they're there in public so that you can watch it if you happen to be in court, or you can get the recording. You can see their questions. What are they thinking about? And when they render a decision, they explain why they've done it, and they explain why they've departed from a previous precedent if they have. This is a very transparent institution in that sense, and it's a very responsible institution, and that's one of the reasons why people don't respect the president these days if you look at the polls, and people don't respect Congress these days if you look at the polls, but they do respect the judiciary. Now, with respect to the decisions this year, I don't think there were as many cases overruling precedent as you say. The Supreme Court decided a number of, the 3 most controversial cases, I suppose, were the late-term abortion case, the campaign financing case, and the school cases, which were decided at the end of the term. Those were all basically 5-4 decisions. They were 5-4 decisions that were departed from previous decisions of the court if you looked at it a certain way. In each case, the majority of the court explained that they did not think that they were overruling previous precedents. They were looking at it in a different way. The court, both liberal and conservative justices, will say that we try to decide the cases in the right way. We do respect precedent. We depart from precedent or distinguish precedent when we feel it's appropriate to do so. In the one case where a precedent was clearly overruled, an antitrust case that I argued, and it did come out the right way. I mean, 5-4, you were disagreed perhaps, but that was overruling a 96-year-old precedent in the antitrust law. And when I explained it to Elliot before we came out on the stage, he said, oh, well, that was just a 96-year-old precedent. That wasn't a 2-year-old precedent. Well, would you argue that it's more important to adhere to those ones or the shorter ones? The court is doing a good job. It came out 5-4, and I gather if we took a vote in this room, you liked it the way it was the other way. But they're close cases. And I said this today, or said it in another context. Is it liberal or conservative? Let's say the campaign finance case. Justice Kennedy was, by the way, there were 24 5-4 decisions, and Justice Kennedy was in the majority in 24. That has not happened very often. But the campaign finance case came out in favor of more freedom with respect to groups who wanted to advertise issues at election time. That's a free speech issue. It may be that the conservative side, I don't know which is more conservative or more liberal, deciding that the Constitution permits more people to speak under more circumstances or less people to speak under elections. I mean, I don't want to see a show of hands about which is liberal, which is conservative, but I think you could argue about that. So, I mean, these arguments can go on, but if you read the explanations of the justices, both in the majority and in the minority in those cases, you will respect the reasoning that goes on and the effort to explain to the American people why we came out why we did.
Thank you, Ted. And you've used the word respect a number of times. And I'd like to turn to Michael, who teaches about American government. You're not a lawyer. One of the remarkable things about our system of government is the respect given to the Supreme Court, especially given that it is not an elected institution. And perhaps now, Ted, you're noting that so many of the justices now stay for a very long time, many presidential terms. Arguably, the framers did not anticipate that presidents would be choosing people in their early 50s, hoping that they would stay in a predictable ideological position for 30 years, and we may be able to talk about that. And you should also very much respect, Ted, the fact that this country accepted your victory in the Bush against Gore case, and that would not be true of many other countries. But I ask you, Michael, is there any risk when the court is as closely divided as it is today, when it is as partisan as it is today, when, whether in fact or in interpretation, it appears to many that precedents are being overruled simply because the change in composition of the court? Is there a risk that this extraordinary institution may be respected less by the public?
Well, it is a striking thing, Elliot, about the court that people obey what it says, even though they don't have any real enforcement mechanisms, unlike the legislative and executive branch. And so people have worried over a long period of time about just how fragile is that legitimacy and the willingness to obey without any force or enforcement mechanism. And people worried about that during the days. Some critics of the Warren Court said that if the Warren Court, in the name of doing good and doing justice, is taking on decisions that many of us in this room would applaud, but if they're reaching beyond their role in interpreting the law, then, and Alexander Bickel worried about this, will people stop according to the court the respect? And a striking thing, whether it was in this question, the Warren Court, or the question as it's arisen now, the legitimacy and the willingness to obey does not seem to have been tainted. I would like to, though, go back to the discussion about precedent and what's liberal and what's conservative. And also in the 5-4, the increase in the 5-4 votes and the decline in the unanimous votes. Now, just reading the room here.
You're very astute at reading the room.
Even though it's very dark, we can't see any of it. But I could hear when Steve gave, when you gave those figures about the decline in unanimous rulings and the increase in 5-4, there was an audible gasp. People didn't like that. They were troubled by it. And then on the issue of precedent, Ted, when you said, or maybe it was Elliot, about the precedents seeming to be more and more overturned, and is this a problem? And there was a great warmth of feeling in this room for stare decisis. Now, when did stare decisis become a great liberal principle? It's an interesting question. Well, it became a great liberal principle when the composition of the court began to change, and we saw this in the confirmation hearings of Chief Justice Roberts and Justice Alito, when the senators who wanted to protect Roe without saying in so many words, instead of talking directly about that, they said, do you respect precedent? And they parsed the distinction between a precedent and a super precedent.
And a super-duper precedent.
Yeah, all of that. So suddenly, adherence to precedent and stare decisis became a great liberal cause. Well, that's because the case that people want protected in the name of precedent is one that liberals agree with. But as Elliot pointed out in the question to Ted, precedent and stare decisis, traditionally adhering to tradition and the weight of the past, rather than launching out on your own anew, traditionally that's a conservative idea. So I agree with Steve when he's in the dissent and when he's in the majority. But I think it's a mistake, regardless of one's opinions on the cases. I think it's a mistake to suddenly put all of the emphasis and to almost to tie the legitimacy of the court to upholding precedent. The discussion, I think, should be about the merits of the cases and the arguments. So let's argue about Roe. Let's argue about those senators who are questioning. Let them ask about Griswold, and if they accept, which was an earlier privacy case. I would rather see, for the sake of public education, but also for the Senate confirmation process, that the attention, that we not shadow box. All this talk about precedent and how unanimous or how divided. We know why it's more divided. The composition of the court changed, and it changed for political reasons. And we knew that when the presidential campaigns were going, we know how that works. So that's what happened. And that's why the vote patterns changed. There's nothing damaging to the republic about more 5-4 votes. That's what the composition of the court that's been created through this political process. So I don't think we should worry about 5-4 votes as such. We should worry about what the votes are for and what the decisions are. And I don't think we should worry about precedent as such. We should worry about whether the precedents are right or wrong, whether the arguments are persuasive or not.
Ted,
I wanted to say one thing. I've heard Justice Breyer do this a couple of times, and these people should hear it. He talks about precedent and the court getting things right sometimes and getting things wrong sometimes, and the respect that the American people have for the court. And he talks about it in such elegant terms. I mean this. I think you should all hear this. I don't know whether you can do it in a short, the period of time that this context permits, but it is beautiful, and it says a lot about the respect that we in America, whatever our politics, have for the Supreme Court, even when they get it wrong and when they get it right. I mean, this is part of the speech.
That's true.
I think you've been given the floor.
All right. Now, the point that I make, which I think is an important point, and you see it physically in the courtroom. I'll explain what I mean by that in a second. But I like to tell the students, I go back to the famous case that probably you've never heard of, nor has hardly anyone, but the Cherokee Indians in 1834 owned some land. They were evicted. The Supreme Court said the land belongs to them, and Andrew Jackson said, John Marshall, the Chief Justice, has made his decision, now let him enforce it. And Jackson sent troops. And the troops did not go to enforce the law. Eventually, they evicted the Indians. And the Indians walked along the Trail of Tears, Oklahoma, where their descendants live. All right, then I want to run the clock forward, and I talk about Little Rock. Because Little Rock was an instance where troops were sent again. That was where, I'm sure you know most of it, Governor Faubus stood in the schoolhouse door, and he said, no black children in this school. And he had the state police. And President Eisenhower sent the troops, the paratroopers, and this time they went to enforce the law. And they took the children by the hand and they walked into the school. I thought that was a great day, great victory for the law, a great victory for the law. And that's when I want to say that I heard actually Senator Reid say this. And I thought, my goodness, I saw him later. He came to it. I said, I so agree with you. He said, the remarkable thing about Bush v. Gore is that which is very rarely remarked. No paratroopers, no rocks picked up on the street, no riots, no nothing. People followed it. I was in dissent. Did I think it was wrong? Absolutely wrong. Absolutely wrong. And a lot of people did. But the amazing thing and the important thing is after a civil war and 80 years of legal segregation and a lot of else, people have learned. And what they've learned, and that's why I come back to what I see every day, what I see every day in that courtroom, I see people of every race, every religion, every point of view. And they've decided to resolve their differences under law. And that is a fabulous thing for this country. And that's what you mean. Now I'll say something you don't agree with. Because I wrote this in a dissent. Now obviously what I think, and you can see a little of emotion in what I'm saying, I think part of that is a way of 300 million people trying to figure out how to resolve their problems themselves in a democratic system while respecting human rights, a degree of equality, etc. And since I think that's what the Constitution is really about, I don't think liberal conservative. I don't think it. Have I trained myself not to think that? Maybe. Maybe it's just 25 years of experience on the bench. I don't think it. I do think, and that's why I said this in the Seattle school case, I do think that first and foremost in that Constitution is a decision, insofar as possible, to let people make up their own minds. What people? Everybody. Everybody. It's an inclusive country. And that's why I felt strongly, because I thought that the interpretation of the Equal Protection Clause that treats the same, which was not my interpretation, it treats the same, whether the discrimination is invidious, whether the discrimination excludes people, whether the discrimination is the kind of discrimination that we saw in the South under segregation. And I think that's not the same, constitutionally speaking, as the kind of discrimination that is inclusive and designed to cure the problems that segregation caused. That's why I thought the colorblind is not true of the Equal Protection Clause. And that's what I spent several minutes and 77 pages explaining. That's right. That's
77
right.
pages,
That's
and I think you were reading all of them to us that day.
I did. I thought
But
maybe I'd
just-
read the whole decision, but I decided not to. Now, I illustrate that because I want you to see what we can feel strongly about. I can feel strongly about a certain vision of the Constitution, about a vision of the Constitution that will define that clause in terms of bringing us together, trying to create a nation, one people, etc. The people who, on the other side, are in perfectly good faith, and they see that interpretation as wrong, mine, and they have a different one. All right, but it's not liberal conservative. It is different views of what that basic document is about. And I'm sorry, I've now been there for 13 years, and I don't think I'm about to change those basic views.
And I don't disagree with that at all, anything that you said. Justice Breyer has written a book called Active Liberty, which explains his approach to the many constitutional questions, which I think most of you know about, but if you don't know about it, you should have, and I guess I should say you should buy.
I'd actually like to follow up and then be thinking, I'm going to give the questions to the audience. Your book, your brilliant little book, it's a quick and wonderful read, Active Liberty, and also things that Michael writes about. One of the principles is almost an obligation for public participation and the strength of democracy because of participation in the political process. And I am wondering why it seems to be, and you talked about shadow boxing in the Senate, that so much of the debate today and dialogue about critical questions about justice and equality and whether the issue is abortion or school busing or campaign finance is relegated to the Supreme Court and are not debated as vigorously as I think maybe the framers intended, Michael, in the other and popular branches of government.
Yeah, I think it has something to do with the fact that in America, and Tocqueville noticed this back in the 1830s when he came, almost every political question is turned into a question about rights, because the idea of rights and of individual rights are so deeply ingrained, not only in the Constitution, in the Bill of Rights, but also in American public culture, in the political culture. We tend not to argue so much in the name of the good society or the good life or even the common good. It's a more natural reflex to think about every dispute and argument and political controversy as a debate about rights, sometimes competing rights, and how they should be resolved. And the court, it's the court's business to interpret the Constitution and to define rights. And I think that's one of the reasons that so many of our public political questions are turned into questions first about rights, and therefore they wind up in court. I'm not sure that's an altogether desirable thing, important as the court is, and of course important as it is to interpret the Bill of Rights, because sometimes what happens is that by pushing everything into the language of rights, and therefore into a legal question, we fail as a society, as a political community, really to address and to thrash out among ourselves the competing conceptions of the good life and of the good society that underlie a lot of our debates about rights. And very often, the justices are forced to think about those questions, but in the language of rights and in the language of law.
I promised questions for the audience. We can't see you, but I do know that we have some microphones, and I ask you to please make your questions short and have them end with a question mark.
Elliot, I've got one. Can I just, as we start the questions, just say on behalf of the Aspen Institute and the Atlantic, is there a better way to celebrate July 4th than talk about the Constitution? I have one question right.
Thank you, Doug Lawrence, J.P. Morgan. Thank you for being here today and talking about the Constitution as you are. The country itself today, between the ages of 0 to 9, is already evenly split, 50% minorities, 50% Anglo-Americans. And what this country has done since its inception is always move toward inclusion. Education being a very important part of inclusion, education being the glue that holds a democracy together, ultimately, we think. Can you elaborate further on the majority opinion in the education case that just happened? Because, frankly, a lot of people don't get it, and it would be helpful to understand it better.
I think that's
Whom
for
are
you.
you asking?
Well, I'm probably not the right one.
That's for you, Ted.
Ted, I think...
Well, let me talk about it a little bit, because I won't take 77 pages. Those two systems in Seattle and Louisville, Kentucky, gave people the right to transfer to schools. It was the public school system. It wasn't just high school. It was went lower than that. And we would have a choice. I know Justice Breyer will correct me if I'm wrong on the facts, but you would have a choice as to which school you would go to. And in both of those systems, if your attendance at that school would push the percentage of your particular race, and in both of those cases, one of them was either black or white, or one of them was either white or non-white or black or not, whatever it was a binary choice. It excluded all the other possibilities that exist in this country. So that if your presence at that school, and your parents wanted you to go to that school, if you pushed the black population of that school above 50% or 15% or whatever the numbers were, you couldn't go to that school. So the choice, and it didn't happen all of the time, but it happened where the percentages were such and such. So that the decision with respect to whether you could go to the school or not was on the basis of race. And Chief Justice Roberts, writing for the court in those cases, said the way to end discrimination on the basis of race is to stop discriminating on the basis of race, stop making decisions on the basis of race. They should be on the basis of all the other things that we choose. The court was split 4-1-4 on this because Justice Kennedy joined the majority in part of the opinion, but said I wouldn't go quite as far as the plurality did with respect to drawing a relatively strong bar against using race to select and to promote diversity and that sort of thing, and on this basis. And Justice Breyer was there that day. It was the last Thursday of the court. Justice Breyer's dissent is a beautiful piece of work. It is very passionately written. The justices on both the majority side and the concurring opinion by Justice Kennedy and by the dissent written by Justice Breyer, and there was a beautiful dissent written by Justice Stevens as well, talked about the meaning of Brown versus Board of Education and whether the majority was faithful to Brown versus Board of Education, and the dissenting opinion in 1890, whatever it was, 8 in Plessy versus Ferguson, about the Constitution being colorblind, or the point that Justice Breyer made a few moments ago about making these decisions for the purpose of inclusion versus exclusion. Chief Justice Roberts said, wait a minute, when you're telling someone they can't go to a school, you may be including somebody, but you're excluding somebody at the same time on the basis of race. In trying to answer that question as fairly as I possibly can, I don't mean to minimize the sensitivity of it, the importance of it, and the good faith of the people in those school systems who are trying to make sure that those schools remained integrated schools and not segregated schools. And on the same time, and I was on the side, I didn't participate in the case, but I had in earlier cases on the side that said we have got to stop making decisions on the basis of race, because that's a cycle that keeps continuing. I say all this, you really need to read. It's a lengthy project, but we're all citizens of this country. Race is one of the most important issues in this country. And there's a lot to be said in those opinions, and we will all have a duty as citizens to read them.
Ted, what they want to hear you address is, what do you say to the obvious argument that is it wrong even where there is no racial prejudice? That's what they want to hear you. Don't you want to take a crack at that?
Well, I believe, and I sort of was taught to believe this, and I've argued cases to believe this, that
it's to overcome.
Well, this was a case where there was not it was arguable whether there was, in both Seattle and Louisville, it wasn't a remedy to specific discrimination. So there may be circumstances where you have to do a fire department, for example, that has excluded all black people. You'll say, well, we've got to use race as a basis. The court has, I guess, even in the arguments that I've made, both as a private lawyer and as a government, we've said that the court has said that under certain circumstances that would be appropriate, but where there isn't a specific remedial objective in mind, deciding someone should get a benefit from the government because they're black, and it's a very complicated, and these cases illustrated it, because one of the points was made, if the school was part Asian, part Hispanic, part black, part white, it still wouldn't have fit some of these definitions under some of those circumstances, because the legislation only took into consideration black versus white, or black versus white versus non-white. And people now are getting to the point where even in the census forms, where a lot of people are declining to state because their backgrounds are not just this or not just that. They don't want to be characterized in that way. And it seems to me, but this is a personal thing, that we need to stop deciding people go into this door or that door or that door, or this drinking fountain or that drinking fountain, because of the genetics as far as their race is concerned. I hope that answers that question.
I mean, you're in a difficult situation here, but
because I'm in a hostile audience.
Yeah, well, that's true. That's true. But so let me just try to see if I'm trying to illustrate the nature of the difference. Look, there was a child who wanted to go to a certain high school in Seattle. Seattle had a rule because it wanted to end forced busing, which it had. It wanted to bring whites back from the suburbs. And it had a rule, you choose whatever school you want. But if the school has fewer than 15% minority, white child, you can't go, we have to let the minority child go. Same was true in Louisville. This little boy wants to go to kindergarten, can't, because that school has whatever percentage. And that child, I admit, is hurt. And the reason that the child is hurt is because of the child's race. I say that's true. Absolutely true. Now, I say there's also a different thing. There also is the kind of harm that occurred in segregated states. Because I think her name was Laura Brown. What was her first name? Brown, in Brown v. Board. She too was told what school to go to because of her race. But my goodness, the harm that was causing was nowhere near the kind of harm in Seattle, where the child in Seattle had to spend 1 year at a high school that maybe he didn't want to go to before he could transfer. All right? So I say they're different harms. Now, why is that relevant to the Constitution? Well, in my view, and this is hard for me to put myself in somebody else's shoes and not say what my view is. My view is it's totally relevant, because what this Constitution is about is ending that situation that existed in the South in 1950, 1940, 1930, and before under slavery. It wants to bring people who suffered from that into our society, and that's what it's trying to do. And therefore, the standard is different. I'm just saying it's different. Now, what do I say there? I'm not even saying if it's good or bad. My view is whether you should have that harm suffered in Seattle or suffered in Louisville by those children is a matter to decide in our legislatures and school boards, not a matter to decide in the Supreme Court of the United States.
Another question.
That wasn't what you...
That isn't what I wrote?
No,
I have the 77-page
no,
opinion
no,
right here.
no,
I'll read you
no.
76 pages.
Oh, I know that's what you wrote,
I know
but I
that's
mean,
what I wrote.
you weren't happy with the decisions being made by the school board in Topeka, Kansas. in
Absolutely
1950.
not, because
Okay.
that was part of a caste system.
Right,
that
because,
ca- yeah,
because,
right.
so it wasn't that it was legislative, local
Oh,
decision.
but that's good. Good, look, good, wonderful point. Because I'm trying to illustrate I'm trying to illustrate for people who aren't all lawyers even. You know, I mean, that's probably to your advantage. But the fact is, I'm trying to illustrate the kind of thing that we're doing. You say, look, which was in the opinion of the Chief Justice, the way to stop discrimination is to stop discriminating. I say, let's think about that. The way to stop the kind of discrimination of the sort that Laura Brown suffered, racial segregation in the South, is to stop discriminating of the kind at issue here, trying to keep a school at least 15% minority. That at least isn't obvious on its face that that's true. And so my view is that the Constitution tells us that it's up to the people to decide that question. It is not up to the people to have segregation in the South. I'm sorry, that's why they wrote the 14th Amendment. They wrote it after the Civil War. They saw what had happened. My goodness, I mean, it was terrible. That's why I feel, I mean, you can, well, we all know that. All right. But that is a difference. So when I see in the law suddenly change, because I said, case after case has said there's a difference between these two things. Case after case. Grutter only most recently, the affirmative action case. So I ended up saying, what has happened to Grutter? Where has it gone? What has happened to Swan? What has happened to McDaniel? What has happened to Crawford? What has happened to Seattle School District? What has happened to Boston School District? They have disappeared from the law. But my reason is not that I'm some tremendous admirer of stare decisis. I do admire it. It does keep stability in the law. It is important to have stability in the law. But what I'm really upset about in this case is here were a set of cases over time that found this distinction. And why do I think that distinction is so important? Well, as a person, I might think what Thurgood Marshall said was right. If our children can't learn together, how are we ever going to learn to live together? He's saying that as a person, as a great civil rights leader. I'll say as a judge that kind of thing is up to the public in the voting process to decide. And so what was motivating me was I suddenly saw this tremendous shift from what I thought was a fairly well worked out distinction in the law that did leave these things up to the school board. And I say, is it that there's no problem? Well, I put this in. I said, one black child out of every 6 is today attending a school which is 99% to 100% black. So it isn't as if there's no problem in the country in respect to this kind of thing. So what does the Constitution say? From my perspective, it says the people have to decide how to deal with this problem. They cannot segregate the way they did in the South, but they can decide what kind of system we're going to use to deal with problems of race, poverty, and to bring people into society. Now remember, you're just getting very strongly presented one point of view. And so I suggest that you also read the point of view of the majority. And then after you read that, you can read 75 and a half of the 77 pages.
Very good.
Another question.
Yeah.
We have a question here.
Yeah, earlier you were
wanted it
talking
together.
about
They wanna hear
reducing everything or putting everything in a context of rights. And I just wanted you to speak to perhaps something where you see property rights and the area of eminent domain being used by municipalities to further real estate developments in certain parts of the country, or just in any one area that may be near a frontage on the ocean or something. And even as we saw in New York, the New York Times, I think, used it through the legislature in New York. But I just wanted you to speak to you if you
To
see
whom are
any.
you asking the question?
Go ahead. Let
Well-
Ted can go.
Yes.
Well, I can
My
talk-
question was regard, do you see a change in the property rights of individual citizens when they come up against the power of the municipality to use eminent domain against them?
Well, I can talk about the particular case that the questioner, and we can't see where you are, asked about was a decision of the Supreme Court a couple of years ago, two or three terms ago, called Kelo, in which the Fifth Amendment to the Constitution of the United States says property may not be taken except for a public purpose upon the payment of just compensation. And so the question is was it a public purpose or public use?
It cannot be taken for public use.
It's public use. So the question, and in Connecticut, I think it was, had taken some property to build a complex of apartment buildings, shopping centers, parking lot for a big corporation and that sort of thing. And the property had been taken from these homeowners. Now, the community argued that, well, this is in the improvement of the community. We will improve the tax base. We'll have a better commercial operation there. It will be beneficial for all of the citizens, and that is a public use. And so the property was taken. These people were evicted from their homes. They did not want to leave. Some of these people had been in their homes for a very, very long period of time. The homes were not, it was not a slum. It was not a blight or anything like that. So the question was, what is a public use? The Supreme Court, by a 5-4 vote, I think, upheld the communities taking that property. I think the decision was written by Justice Stevens. And the question was, what is a public use? And now that is a very complicated question. Justice Breyer will answer that much better than I do. But what is a public use? We take property from citizens for roads. No one really has a problem with that. And for bridges and maybe for airports. But what about baseball stadiums, you know? And what about other different things? What about when communities try to improve blighted areas? What about when property is taken to create industrial complexes and that sort of thing? So the very intense debate on the Supreme Court was, what is a public use? The Supreme Court decided by a 5-4 vote that that's pretty much, I can't remember where Justice Breyer was, but he'll tell us, that the community had decided and made that decision. It wasn't for the court to override the legislative body's decision with respect to what is a public use. Justice O'Connor, as I recall, wrote a very, very strong dissenting opinion. The one that attracted me the most was a dissenting opinion by Justice Thomas, who went way back to the history of eminent domain and what it was done in England and so on and so forth, and what is a public use. Is it something where the public is actually going to be using the property, or is it just something that might enhance the value of the community? Now, once the Supreme Court, and I thought it was really an interesting dissenting opinion, once the Supreme Court decided this case, and I think a lot of people were surprised that it was as controversial as it was, there was an outrage all across the country, and that's maybe what motivates the question of what in the world is government doing, coming in and taking property, because somebody who's, Justice O'Connor's point says, what's the difference between taking property for a hotel 8 or whatever those hotels are, or a Ritz-Carlton, you know. Why do governments get to decide that it might be better for the community to have an expensive hotel which pays more taxes? Maybe that's better for the tax base, maybe it isn't, but is that constitutionally justified? So that's the issue. It's a really interesting issue.
Yeah, my reaction was very much like Ted's. I didn't see this as a big major case. And I suppose the reason because it was a little more, a little less kind of case. And what happened, I think, was that example. Because the example that Justice O'Connor used in opinion began to, when it was written in the newspapers, people all over the country thought that what this decision means is they're going to go take my house and give it to Donald Trump. And that, of course, produced a reaction. It's not unusual in history that people take private property to give to some other private person. Think of the railroads. We built the railroads, and there's a railroad crossing, and for a railroad crossing to exist, you have to take somebody's property and have an easement so the railroad can use it. Think of our electricity system across the country. The question is just what Ted says. When are you going too far? When aren't you going too far? You want to build an Olympic stadium? That's for the public, no problem. Well, suppose there's a private ice cream vendor. I mean, so what? What's a little more? What's a little less? Nobody's going to give any houses to Donald Trump. And the question was, how do you do that? You're quite right. I agree with you. It was
There we go. There we go.
Well, I am terribly sorry because we could keep going on all evening. But I've been told, though, unless, Ted, you're going to take up the guitar, but I do want to thank all
They would really boo.
I don't think so. And thank all of you for being here. And a special thanks also to Michael Goldberg and Belly Up.